leave all the references to the defendant testifying taken out, references to the aspect we already talked about.
Your Honor, do you want to bring the defendant up?
Yes, absolutely. Thank you. Grant motion. I'll ask if there's any tweaks about either side.
Your Honor, I didn't realize, this makes sense, but I didn't realize that, I guess reckless homicide comes after ag assault just because it's lesser. I didn't know that.
Then the E felony of criminally negligent homicide is down there too.
Yeah, that's interesting. I've never noticed that.
Both sides, if you want to go straight to the abuse of court, you certainly can. Again, I think the references to, again, the defendant testifying was the last thing I wasn't sure about. That's been modified to show that he hasn't testified and the jury can't hold anything against him for that. But once the parties finish reviewing it, probably do a proceeding for the jury.
Your Honor, with the impeachment of a witness, I think there might be the beginning of a sentence that might have been deleted that's not all there.
What page are you looking at?
There's no page number, just impeachment of the witness. There's 3 paragraphs. The last paragraph, it starts off with impeach.
Thank you. When the testimony of a witness is impeached, the jury has the right to disregard.
Yes, sir. instruction for a prior statement of defendant?
I kept that because wasn't there testimony about when Ms. Pace, Katrina Pace, was talking to the police officers, they said that he gave statements that were...
There was also the written statements that were collected and all that.
Okay.
That's a good one.
Okay. Good to go? Both sides ready to proceed?
Yes, sir.
Bring the jury in when they're ready, please. All right, please be seated. Ladies and gentlemen, I'm about to read final jury instructions. Please pay attention. You don't have to write them down. You will all have a copy. There will be at least one, probably several copies back to the jury as you deliberate. But pay attention because the issues that are in these instructions do pertain to the issues that came out during trial. And so there may be one or two things that you see that you want to follow up with. And of course, the parties will follow up with them as well when they do their regular closings. Members of the jury, the evidence in this case has been completed. You will now be instructed as to the law applicable in the case. This covers your duties and the general rules that apply in every case. It also covers the offenses that are charged and included in the presentment and lists their elements. It includes some rules that you must use in evaluating particular testimony and evidence. Finally, it also includes the rules that you must follow during your deliberations in the jury room and the possible verdicts that you may return.
Your Honor, I'm sorry. Are you intending for this to be scrolled?
Actually,
Didn't know. I apologize.
no. Thank you, gentlemen. It is your duty to carefully consider all these instructions. The order in which these instructions are given is no indication of their relative importance. Moreover, do not assume that because a particular instruction is given, it suggests anything about the facts of this case.
You should not single out any one or more instructions to the exclusion of one or more others, but you should consider each instruction in light of and in harmony with the others. Count 1 of presentment 315-228 charges the defendant, Jason Chen, with the offense of first-degree premeditated murder on or about November 23rd, 2022, Hamilton County, Tennessee. This charge includes the following offenses: first-degree premeditated murder, second-degree murder, voluntary manslaughter, aggravated assault, reckless homicide, reckless aggravated assault, criminally negligent homicide, assault, and reckless endangerment. Count 2, the presentment 315-228, charges the defendant, Jason Chen, with the offense of abuse of a corpse on or about November 23rd, 2022, in Hamilton County, Tennessee. This charge includes the following offense: abuse of a corpse. The presentment in this case is the formal written accusation charging the defendant with one or more crimes. It is not evidence and does not create any inference of guilt. To presentment 315-228, the defendant, Jason Chen, pleads not guilty. The plea operates in law as a denial of every allegation of guilt contained in the presentment and every element of fact in the offenses charged in the presentment. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless from all the evidence in the case you determine beyond a reasonable doubt that the defendant is guilty of an offense charged or included in the presentment. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt. This burden never shifts, but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. The state has the burden of proving beyond a reasonable doubt all of the elements of the offense, and that the offense was committed before the presentment was found and returned on March 3rd, 2023. The state has the burden of proving by a preponderance of the evidence that an offense charged or included in the presentment was committed in Hamilton County, Tennessee. Proof by preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. The venue of an offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by preponderance of the evidence that an offense charged or included in the presentment was commenced or consummated in Hamilton County, Tennessee, you must return a verdict of not guilty. At times during the trial, the court has ruled upon the admissibility of evidence. Do not concern yourself with these rulings, either by such rulings, these instructions, or any other remarks that I've made. Do I mean to indicate any opinion as to the facts or as to what your verdict should be? Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. You are the exclusive judges of the facts in the case. You are also the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all the evidence in the light of your own observations and experience in life. Any person who commits the offense of first-degree premeditated murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the victim, and 2, that the defendant acted intentionally, and 3, killing was premeditated. context of this offense, a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion. The accused commits the act after the passion has subsided. Any person who commits second-degree murder is guilty of a crime. To find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, the defendant acted knowingly. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. In the context of this offense, a person acts knowingly when a person acts with an awareness that his or her conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. In the context of this offense, a person acts intentionally when the person acts with a conscious objective or desire to cause the death of the alleged victim. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions, which renders the mind incapable of cool reflection. In the context of this offense, a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. In the context of this offense, a person acts knowingly when a person acts with an awareness that his or her conduct is reasonably certain to cause the death of the alleged victim. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intentionally or knowingly caused bodily injury to another, and 2, the act resulted in the death of another. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. In the context of this offense, a person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. In the context of this offense, a person acts knowingly with respect to the nature of circumstances surrounding or result of his or her conduct when the person is aware of the nature of the conduct, that the circumstances exist, so that the conduct is reasonably certain to cause the result. Any person who commits the offense of reckless homicide is guilty of a crime. If you find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, and 2, that the defendant acted recklessly. In the context of this offense, a person acts recklessly and the person is aware of it, but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, the person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. In the context of this offense, a person acts knowingly when the person is aware that his or her conduct is reasonably certain to cause the death of the alleged victim. Any person who commits the offense of reckless aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant recklessly caused bodily injury to another, and 2, that the act resulted in the death of another. Bodily injury includes a cut, abrasion, bruise, a burn or disfigurement, and physical pain or temporary illness, or impairment of the function of a bodily member, organ, or mental faculty. In the context of this offense, a person acts recklessly with respect to circumstances surrounding the conduct or the result of his or her conduct the person is aware of, but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, a person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. In the context of this offense, a person acts knowingly with respect to the nature of, circumstances surrounding, or result of his or her conduct, and the person is aware of the nature of the conduct, that the circumstances exist, that the conduct is reasonably certain to cause the result. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, and 2, that the defendant acted with criminal negligence. The person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise with all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. In the context of this offense, the person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. In the context of this offense, the person acts knowingly and the person is aware that his or her conduct is reasonably certain to cause the death of the alleged victim. In the context of this offense, the person acts recklessly and the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. If you find beyond a reasonable doubt that the defendant was criminally negligent, you must also find that the death of the alleged victim was the proximate result of the defendant's criminal negligence. The defendant's actions need not be the sole or immediate cause of death. If you find that the direct cause of death was an act of the victim or third party, before you can convict the defendant, you must also find beyond a reasonable doubt that the act of the victim or third party causing the death was a natural and probable result of the defendant's criminal negligence. Any person who commits the offense of assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements: that the defendant intentionally, knowingly, or recklessly caused bodily injury to another. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness, or the impairment of a function of a bodily member, organ, or mental faculty. In the context of this offense, a person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. In the context of this offense, a person acts knowingly with respect to the nature of, circumstances surrounding, or result of his or her conduct, and the person is aware of the nature of the conduct, that the circumstances exist, and that the conduct is reasonably certain to cause the result. In the context of this offense, a person acts recklessly with respect to circumstances surrounding the conduct or the result of his or her conduct, and the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. Any person who commits the offense of reckless endangerment is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury, and 2, that the defendant acted recklessly. The threat of death or serious bodily injury to be imminent, the person must be placed in a reasonable probability of danger as opposed to a mere possibility of danger. Before you can convict the defendant, the state must show beyond a reasonable doubt that a person or class of persons was in the zone of danger. The zone of danger is that area in which a reasonable probability exists that the defendant's conduct would place others in imminent danger of death or serious bodily injury. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, physical pain or temporary illness, or impairment of the function of a bodily member, organ, or mental faculty. In the context of this offense, a person acts recklessly with respect to circumstances surrounding the conduct or result of his or her conduct, and the person is aware of, but consciously disregards, a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, a person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. In the context of this offense, a person acts knowingly with respect to the nature of, circumstances surrounding, or result of his or her conduct, and when the person is aware of the nature of the conduct, that the circumstances exist, or that the conduct is reasonably certain to cause the result. Any person who commits the offense of abuse of a corpse is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1A, that the defendant physically mistreated the corpse in a manner offensive to the sensibilities of an ordinary person, or B, that the defendant disposed of a corpse in a manner known to be in violation of Tennessee Code Annotated 39-14-505, which defines the offense of aggravated criminal littering as littering in amount exceeding 10 pounds in weight or 15 cubic feet in volume, and that the defendant acted without legal privilege, and that the defendant acted knowingly. In deciding whether the act was offensive to the sensibilities of an ordinary person, the jury must avoid subjective, personal, and private views and evaluate the sensibilities of a hypothetical average adult person and find the collective view of the adult community as a whole. Ordinary person means a person of ordinary care and diligence in relation to a particular thing. Littering means knowing, placing, dropping, or throwing litter on any public or private property without permission and not immediately removing it. Litter includes garbage, refuse, rubbish, and all other waste material. Garbage includes putrescible, animal, and vegetable waste resulting from the handling, preparation, cooking, and consumption of food. Refuse includes all putrescible and non-putrescible solid waste. Legal privilege means a particular or peculiar benefit or advantage created by law. A person acts knowingly with respect to the nature of, circumstances surrounding, or result of his or her conduct, and the person is aware of the nature of the conduct, the circumstances exist, that the conduct is reasonably certain to cause the result. The requirement of knowledge is also established if it is shown that the defendant acted intentionally. A person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Before the defendant can be convicted of any degree of homicide, the state must have proven beyond a reasonable doubt that the death of the deceased was approximately caused by the criminal conduct of the defendant. The proximate cause of death is that cause which, in natural and continuous sequence, unbroken by any independent intervening cause, produces death without which the death would not have occurred. The defendant's conduct need not be the sole or immediate cause of death. The acts or omissions of two or more persons may work concurrently to proximately cause the death. And in such a case, each of the participating acts or omissions is regarded as a proximate cause. It is not a defense that the negligent conduct of the deceased may also have been a proximate cause of the death. However, it is a defense to homicide if the proof shows that the death was caused by an independent intervening act or omission of the deceased, or another which the defendant, in the exercise of ordinary care, could not reasonably have anticipated is likely to happen. However, if, in the exercise of ordinary care, the defendant should reasonably have anticipated the intervening cause, that cause does not supersede the defendant's original conduct, and the defendant's conduct is considered the proximate cause of the death. It is not necessary that the sequence of events or the particular injury be foreseeable. It's only necessary that the death followed in the general field of danger, which the defendant should have reasonably anticipated. If some other circumstance caused the victim's death, unrelated to the defendant's actions, that would be a defense to homicide, unless the circumstance was the natural result of the defendant's act. If you find that the defendant's acts, if any, did not unlawfully cause or contribute to the death of the deceased, or if you have a reasonable doubt as to this proposition, you must find him not guilty. The court charges you that the identity of the defendant must be proven in the case on the part of the state to your satisfaction beyond a reasonable doubt. In other words, the burden of proof is on the state to show that the defendant now on trial before you is the identical person who committed the charge or an included offense. In considering the identity of a person, the jury may take into consideration all the facts and circumstances in the case. The court further charges you that if, from the whole proof in the case, you are satisfied beyond a reasonable doubt that the defendant committed the charge or an included offense, and you are satisfied beyond a reasonable doubt that he has been identified as the person who committed the charge or included offense, then it would be your duty to convict him. On the other hand, if you are not satisfied with the identity from the proof, or you have a reasonable doubt as to whether he has been identified in the whole body of proof in the case, you should return a verdict of not guilty. The guilt of the defendant, as well as any fact required to be proved, may be established by direct evidence, by circumstantial evidence, or by both combined. Direct evidence is defined as evidence which proves the existence of the fact of issue without inference or presumption. Direct evidence may consist of testimony of a person who has perceived by the means of his or her senses the existence of a fact sought to be proved or disproved. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove the fact of issue, but from which that fact may be logically inferred. It is your duty to decide how much weight to give the direct and circumstantial evidence. The law makes no distinction between the weight that you should give to either one, or say that one is any better evidence than the other. You should consider all the evidence, both direct and circumstantial, and give it whatever weight you believe it deserves. It is your job to decide what the facts of this case are. You must decide which witnesses you believe, how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules for judging whether you believe a witness. It may help you to think about these questions. 1. Was the witness able to see or hear clearly? How long was the witness watching and listening? Was anything else going on that might have distracted the witness? 2. Did the witness seem to have a good memory? 3. How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Did the witness seem to evade the questions? 4. Has there been any evidence presented regarding the witness's intelligence, respectability, or reputation for truthfulness? 5. Does the witness have any bias, prejudice, or personal interest in how the case is decided? 6. Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? 7. In general, does the witness have any special reason to tell the truth or any special reason to lie? 8. All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. You may conclude, however, that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things, but told the truth about others, you may simply accept the part you think is true and ignore the rest. The testimony of a witness may be discredited or impeached by careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. The testimony of a witness may also be impeached by proving that he or she has made a prior inconsistent statement, that is, a material statement that he or she made out of court that is at variance with his or her testimony on the witness stand. However, the earlier statement is brought to your attention for the sole purpose of discrediting or casting doubt on the accuracy of the witness's present testimony here at the trial. You may not use the witness's earlier statement as proof that something said in it is true. When the testimony of a witness is impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony and by the facts and circumstances proved on the trial. During the trial, you heard expert testimony. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it's up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. The court instructs you that fathers evidence of an oral or written statement given by the defendant in this case. You may take it into consideration with all the other facts and circumstances proven in the case. While this evidence has been received, it remains your duty to decide if in fact such statement was ever made. If you believe the statement was not made by the defendant, you should not consider it. If you decide the statement was made by the defendant, you must judge the truth of the facts stated. In so determining, consider the circumstances under which the statement was made. Also consider whether any of the other evidence before you tends to contradict the statement in whole or in part. You must not, however, arbitrarily disregard any part of any statement, but rather should consider all of any statement you believe was made and is true. You are the sole judge of what weight should be given to such statement. If you decide the statement was made, you should consider with all the other evidence in the case in determining the defendant's guilt or innocence. If from the proof you find that the defendant has committed acts other than those for which he is on trial, you may not consider such evidence to prove his disposition to commit crimes such as those for which he is on trial. This evidence may only be considered by you for the limited purpose of determining whether it provides 1. The complete story of the crime. That is, such evidence may be considered by you where the prior acts and the present alleged crime are logically related or connected or a part of the same transaction, so that proof of the other tends or is necessary to prove the one charged or is necessary for a complete account thereof. 2. A scheme or plan. That is, such evidence may be considered by you if it tends to establish that the defendant engaged in a common scheme or plan for the commission of 2 or more crimes so related to each other that proof of one tends to establish the other. 3. The defendant's intent. That is, such evidence may be considered by you if it tends to establish that the defendant actually intended to commit the crime with which he is presently charged. Guilty knowledge. That is, such evidence may be considered by you where guilty knowledge is an essential element of the crime charged, and evidence of the other acts tend to establish that the defendant possessed this knowledge at the time of the commission of the crime presently charged. Such evidence of other acts, if considered by you for any purpose, must not be considered for any purpose other than that specifically stated. The state has a duty to gather, preserve, and produce at trial evidence that may possess exculpatory value. Such evidence must be of such a nature that the defendant would be unable to obtain comparable evidence through reasonably available means. The state has no duty to gather or indefinitely preserve evidence considered by a qualified person to have no exculpatory value, so that as yet unknown defendant may later examine the evidence. If, after considering all the proof, you find that the state failed to gather or preserve evidence, the contents or qualities of which are at issue, and the production of which would more probably than not be of benefit to the defendant, you may infer that the absent evidence would be favorable to the defendant. The flight of a person accused of a crime is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charged. Whether the evidence presented proves beyond a reasonable doubt that the defendant fled is a question for your determination. The law makes no precise distinction as to the manner or method of flight. It may be open, or it may be a hurried or concealed departure, or it may be a concealment within the jurisdiction. However, it takes both a leaving of the scene of the difficulty and a subsequent hiding out, evasion, or concealment in the community, or a leaving of the community for parts unknown to constitute flight. If flight is proved, the fact of flight alone does not allow you to find that the defendant is guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the fact of flight, if flight is so proven, together with all the other evidence when you decide the guilt or innocence of the defendant. On the other hand, an entirely innocent person may take flight, and such flight may be explained by proof offered or by the facts and circumstances of the case. Whether there was flight by the defendant, the reasons for it, and the weight to be given to it are questions for you to determine. Any attempt by a person to conceal evidence is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Whether the evidence presented proves beyond a reasonable doubt that the defendant concealed evidence is a question for your determination. If this fact is proven, it alone does not allow you to find the defendant is guilty of the crime alleged. A person entirely innocent of a particular crime may attempt to conceal evidence, and the concealment may be explained by proof offered or by the facts and circumstances of the case. However, because an attempt by a defendant to conceal evidence may be caused by a consciousness of guilt, you may consider this fact, if it is so proven, together with all the other evidence when you decide the guilt or innocence of the defendant. It is for you to determine whether there was any attempt to conceal evidence by the defendant, the reasons for it, and the weight to be given. The court has charged the jury concerning an inference the jury may make in regard to certain evidence in this case. However, the jury is not required to make this inference. It is the exclusive province of the jury to determine whether the facts and circumstances shown by all the evidence in the case warrant the inference which the law permits the jury to draw. The inference may be rebutted by direct or circumstantial evidence, or both, whether it exists in the evidence of the state or is offered by the defendant. Although the defendant is not required by law to do so, when the defendant offers an explanation to rebut the inference raised, you should consider such explanation along with all the evidence to determine not only the correctness of the inference, also to the reasonableness of the defendant's explanation. You are not bound to accept either the inference or the defendant's explanation. The state must prove beyond a reasonable doubt every element of the offense before the defendant can be found guilty. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take a stand in his own behalf. His election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. During your deliberations, you must not communicate with or provide any information to anyone about this case by any means outside the jury deliberation room. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, iPhone, computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including but not limited to Facebook, LinkedIn, YouTube, Snapchat, Instagram, Google, Twitter, or any other social media to communicate to anyone any information about this case, or to conduct any research about this case until you have returned your verdict and the trial has concluded. During this trial, you have been permitted to take notes for your own use during your deliberations. The notes you may have taken should not be considered to be a transcript of the testimony. As such, once you retire to the jury room, you may refer to your notes, but only to refresh your own memory. You may not read from your notes to your fellow jurors or otherwise inform them of what you have written. The notes may contain errors. They may be understood or taken out of context, since they could only pertain to part of the testimony and are not an exact account of what was said by the witness. You are free to discuss the testimony of the witnesses with your fellow jurors, but each juror must rely on his or her own memory as to what a witness did or did not say. Upon conclusion of your deliberations, the court will collect and destroy all of the notes taken by any juror. Count one of the presentment includes, in addition to the charged offense, one or more lesser offenses. The offenses are listed in order from greatest to least. In reaching your verdict on count one of the presentment, you shall first consider the offense charged in the count. If you unanimously find the defendant guilty of the charged offense beyond reasonable doubt, you shall return a verdict of guilty for the charged offense. If you unanimously find the defendant not guilty of the charged offense, or have a reasonable doubt of the defendant's guilt of the charged offense, you shall then proceed to consider whether or not the defendant is guilty of the next listed offense. You shall not proceed to consider any lesser included offense, so you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or if you unanimously have a reasonable doubt the defendant's guilt of the immediately preceding greater offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in count one, you shall return a verdict of not guilty on that count. The crime charged in each count of the presentment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty on one or both counts. Your finding as to each count must be stated in your verdict. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so while respecting individual judgment. Each of you must decide the case for yourself. Do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. Do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations, ensure that they're conducted in a business-like way, and everyone has a fair chance to be heard. When you have reached a verdict, you will return with it to this courtroom, and your foreperson will deliver the verdict forms to the court. If you find that the state has proven the defendant guilty beyond a reasonable doubt, then you should find him guilty. If, however, you find that the state has not proven the defendant's guilty beyond a reasonable doubt, or if you have a reasonable doubt as to the defendant's guilt, you must find him not guilty. You will be provided with forms of all possible verdicts in this case. The jury will complete the forms, and your foreperson will sign and date them. The verdict forms that you will receive read as follows. With respect to count 1, Resolution 315-228, we, the jury, find the defendant, Jasmine Chen, please mark one of the following verdicts: guilty of first-degree murder, guilty of first-degree premeditated murder, or guilty of second-degree murder, or guilty of voluntary manslaughter, or guilty of aggravated assault, or guilty of reckless homicide, or guilty of reckless aggravated assault, or guilty of criminally negligent homicide, or guilty of assault, or guilty of reckless endangerment, or not guilty. With respect to count 2 of Resolution 315-228, we, the jury, find the defendant, Jasmine Chen, please mark one of the following verdicts: guilty of abuse of a corpse, or not guilty. Members of the jury, you have heard and seen all the evidence in the case. After lunch, parties will have the opportunity to present their closing arguments. Under the rules of criminal procedure, the state will argue first, and the defendant will have an opportunity to present his closing argument. The state may then, if it chooses, argue in response or in rebuttal to the defendant's argument. Closing arguments are designed to present to you the parties' theories about what the evidence has shown and what conclusion may be drawn from the evidence. Remember, what is said in closing arguments is not evidence. We've already heard and seen all the evidence in this case that we may properly consider. During their closing arguments, the parties may mention points of law or refer to these instructions that the court has given you. However, the law that you must follow in reaching your verdict is the law that the court has given to you in these final instructions. If there's any difference between what the parties say about the law, what this court has said in these final instructions, you must follow the court's instructions. Ladies and gentlemen, those are the instructions. It is 12:20. Terry, can you approach the line, please?
Yes, sir.
You're going off campus, so we're going to take an hour-and-a-half lunch. So I'll give you time to have lunch, be prepared. The arguments will probably be lengthy. It's 12:20, so parties and jury be back here at 10 minutes to 2. Voting on. Needs to bring up before we take our lunch recess?
No, you're
After the reading of the jury instructions, it's not so much an objection, it's just a question for the court. Do you perceive there to be an issue with the use of corpus instruction? Because, well, first off, I'm not sure if that's a
Please, you see, basically the state has alleged to the series of abuse of courts, one that was treated in a manner that offended the sensibilities of an ordinary person, and two, that it was in violation of a law.
If he's found guilty of that offense, we won't know of which one.
Jeremy, got a response to that?
No, Your Honor, I'm actually not sure under this statute whether election is required. If the court wants to play it safe and require that the jury pick one or the other, maybe that's the safest route to go, but I haven't looked up, the jury instruction says or. So we can research it, but I'm also for appellate review purposes fine with requiring the jury to choose which one.
I do know that we've given it to juries, like aggravated burglary cases, for example, felony theft or assault is the indictment. That's been found to be fine. So I don't think there's no problem so far. To be safe, I may add in that final form for use of the corpse one or two theories, but I have to check one or the other.
You could do that. It also makes me think of aggravated assault. We are not required to elect under which category of aggravated assault, so I'm not sure if it's analogous or not, but we're not required to elect. It can either
Fine so far, just whether or not
Sure.
the jury instruction should be tweaked.
Aggravated assault, I think, is a continuing offense. I don't know if abuse of force is, I guess it could be, but I'm not sure.
Based on the littering component of it, of course, I think it probably lends itself to the fact that it might be. Right? The litters.
I have never considered the issue.
Okay, let's do this then. Do one more thing I get to look at over lunch. You guys enjoy lunch. I'll get ready for your closing, I should say, and I'll let you know what I'm going to get.
Thank you, Judge.
Thank you. Recess till 1:50.